It was supposed to be just another lively academic panel, an annual tradition at the prestigious Ashton University, where scholars from across the country gathered to debate pressing constitutional issues. The auditorium, packed with students, faculty, and invited guests, buzzed with anticipation. At the center of the polished wood stage sat 5 chairs under glaring lights. One of them remained empty until the last moment. The conversation had already begun when John Neely Kennedy slipped into the room. Dressed in a modest navy suit and wearing the calm expression of someone unfazed by intellectual showdowns, he moved quietly to his seat at the end of the panel. Few recognized him at first, and those who did offered only brief glances. After all, this was an academic event, and Kennedy, a senator from Louisiana, wasn't known for mixing with elite law circles. The moderator, a soft-spoken professor of legal ethics, introduced the speakers. Dr. Raymond Talcott, a Harvard-educated constitutional theorist with a reputation for razor-sharp debate, wasted no time in asserting dominance. As always, Talcott began with a smug grin, it's a pleasure to discuss the Constitution with legal minds from most corners of the country. Though I must admit, he added, glancing sideways at Kennedy, some law degrees carry a bit more weight than others, no offense intended. A few students chuckled, others looked around nervously. Kennedy didn't flinch. He simply folded his hands in his lap and watched as Talcott continued, diving into the complexities of judicial review with the enthusiasm of a man giving a TED Talk. Talcott leaned back, enjoying the momentum. It's one thing to study constitutional law at, say, Yale or Harvard, where the doctrine is alive, challenged, refined. It's quite another when your training comes from a regional school known more for football than federal law. This time the laughter was louder. Kennedy's alma mater, Louisiana State University, was the unspoken target. Talcott didn't need to say it outright. Kennedy sat still, his face unreadable. And yet, Talcott continued, clearly enjoying the spotlight, we welcome all voices here. After all, the Constitution belongs to every citizen, regardless of where they studied it. The moment hung awkwardly in the air. A few heads turned toward Kennedy, curious whether he would respond. But the senator remained silent, allowing Talcott to revel in the attention a little longer. Across the auditorium, phones were raised discreetly. Some students whispered to each other, wondering if they were witnessing something historic, or just an academic roast that had gone too far. Talcott, sensing his audience's energy, doubled down. I often say that constitutional nuance can get lost when law becomes just a stepping stone to politics. Theory suffers when ambition takes precedence. More laughter. The moderator cleared his throat, trying to steer the conversation back to the intended topic, judicial interpretation in modern governance. But the dynamic had shifted. A quiet tension now filled the room. Everyone wondered, would Kennedy respond? Before we continue, make sure to hit that subscribe button. You won't want to miss what comes next in this unexpected intellectual face-off, because trust me, the silence won't last long. John Neely Kennedy sat with the posture of a man who had been underestimated more times than he could count. While the room bristled with murmurs and glances, he remained still, almost serene. Dr. Talcott, sensing he had the upper hand, pressed on with confident eloquence, lecturing the room with the air of a man auditioning for intellectual supremacy. His cadence was fast, his tone theatrical. Citations from obscure legal treatises rolled off his tongue like memorized lines. Let's not forget, Talcott declared, that the Constitution isn't merely a document of rights, it's a living organism of jurisprudential tension. Only those who've studied its heartbeat closely can truly interpret its rhythm. There were nods from the front rows, particularly among the younger professors. Yet even as Talcott spoke, the weight of his earlier ridicule hung over the discussion. The moderator, clearly sensing the imbalance, cleared his throat. Senator Kennedy, he said, trying to inject balance, would you care to respond? The room hushed. Kennedy looked up slowly, then nodded once. He didn't reach for notes or adjust his microphone. He simply leaned forward, hands still folded. I appreciate the opportunity, he said, his voice calm, unhurried. The southern drawl was unmistakable. but it carried none of the stereotypes some expected. It was measured, deliberate, thoughtful. For all the talk about the Constitution being a living organism, Kennedy began, we sometimes forget that it's also a contract written in plain words, words meant to be understood by the people who ratified them. Some brows lifted. It wasn't what anyone had expected. The law, Kennedy continued, ain't supposed to be an ivory tower puzzle. It's supposed to be a shield for the ordinary person, a tool for justice, not just theory. Talcott smirked, clearly unthreatened. Senator, he interrupted, with respect, constitutional interpretation requires a level of sophistication that can't be found in populist metaphors. Kennedy didn't blink. I wasn't aware plain English was a populist metaphor. A ripple of laughter ran through the room, not mocking but surprised. Kennedy smiled faintly, then returned to his point. I've spent more time in courtrooms than classrooms, he said, not the kind with marble columns but real ones, where people show up afraid they'll lose their homes or kids or freedom. He paused, letting the words settle. That's where you find the Constitution at work, not in tenured lectures, but in tough questions asked by tired people hoping for fair answers. Talcott shifted in his seat, but Kennedy wasn't looking at him anymore. His attention was on the students, on the future lawyers in the room. The brilliance of our Constitution, Kennedy said, isn't that it's perfect. It's that it trusts the people. It assumes they can read, think, and choose, that they don't need translations from the mountaintop to understand their rights. Another silence, but this one felt heavier. The laughter had stopped. The smirks had faded. Even the moderator leaned forward. Talcott attempted to reassert himself. And yet, Senator, wouldn't you agree that interpreting such a foundational document requires a certain pedigree? Kennedy looked directly at him now. No, Professor. I believe it requires integrity, clarity, and a deep respect for the people it serves. And with that, he sat back again. No theatrics, just truth plainly spoken. There was a shift in the air now, subtle but undeniable. Dr. Talcott, still perched in his chair with academic precision, realized he had underestimated his opponent. Kennedy's words had landed with more weight than anyone expected, but it was only the beginning. Clearing his throat, Kennedy leaned forward again, his tone unchanging yet now sharpened by momentum. You mentioned earlier, Professor, that only those who've studied the heartbeat of the Constitution can feel its rhythm. I agree, but I might add, that rhythm isn't found only in Cambridge seminar rooms. He paused briefly. I remember one case back in Louisiana, a single mother accused of theft. Her public defender couldn't make it, so I stepped in. The issue wasn't the crime, it was the process. The court was trying to fast-track her plea without counsel. The Sixth Amendment doesn't make exceptions for poor scheduling. Now the room was still. Even Talcott didn't interrupt. The judge, Kennedy continued, said it was a harmless error. I quoted Gideon versus Wainwright, and I reminded him that the right to counsel isn't a technicality. It's a pillar. A few students scribbled notes. Others leaned in, no longer seeing Kennedy as just a politician. You see, he said, voice firm, the Constitution isn't preserved in theory. It's preserved in action. Then, turning gently toward Talcott, Kennedy shifted his focus. Earlier, you spoke of judicial review like it was sacred ground, but you skipped over Marbury versus Madison, didn't you? Talcott blinked. Of course not. It's the foundation of judicial authority. Kennedy nodded. Right. And what did Chief Justice Marshall say there? That it is emphatically the duty of the judicial department to say what the law is, not what the law should be, not what we wish it were. Talcott opened his mouth, then closed it again. Kennedy pressed on, this time with more precision. That distinction matters, Professor. Because when judges start creating law instead of interpreting it, they overstep the very bounds the Constitution was designed to protect. Now students looked back and forth between them. The momentum had clearly shifted. Talcott tried to recover. That's a simplification. Constitutional interpretation has evolved. Look at Griswold, Roe, Obergefell. I know those cases, Kennedy said calmly. And I also know how courts arrived at them. The reasoning may be elegant, but the foundation matters. When courts untether their decisions from text and history, they risk making policy rather than law. He wasn't yelling. He didn't need to. And when that happens, Kennedy continued, it's not just an academic problem. It's a democratic one. There was a beat of silence before he added, you see, the law is powerful not because it belongs to scholars, but because it belongs to everyone. When interpretation drifts too far from the original meaning, it starts to drift away from the people. A murmur ran through the room, agreement perhaps, or awe. Kennedy paused, then delivered the line that would echo beyond that auditorium. Constitutional law isn't about which school you attended. It's about whether you understand who the law is meant to protect, and why that protection matters. Even the moderator, normally a silent facilitator, looked genuinely moved. Talcott adjusted his glasses, suddenly unsure of how to respond. His previous confidence had become caution. He searched for a retort, but the silence around him had grown loud. Kennedy didn't press further. He had made his point, not with arrogance, but with clarity, and everyone knew it. Dr. Talcott had built his reputation on quick wit and aggressive argumentation, but now his usual rhythm was faltering. Kennedy's last words lingered in the air like a challenge too precise to dismiss. The room, once dominated by academic chatter and smug laughter, had turned into a quiet chamber of reflection. But Kennedy wasn't finished. If we're going to talk about precedent, he said, his tone still steady, then let's be honest about how it's used. Precedent should be a guide, not a crutch. And certainly not a tool for rewriting what the Constitution never said. He leaned forward slightly, not in aggression, but with purpose. You cited Griswold Roe and Obergefell earlier, powerful cases. But there's a difference between using precedent to illuminate principles and using it to invent new ones. Talcott raised a finger, preparing to interrupt, but Kennedy held up his hand gently. I'm not here to debate outcomes. I'm here to defend the process. Because if we twist the Constitution to get the results we like today, we open the door for others to twist it tomorrow. A murmur of agreement stirred in the back rows. Students were no longer watching a debate. They were witnessing a recalibration of the entire room's dynamic. Kennedy continued, his voice calm but relentless. You studied under Lawrence Tribe, right? Talcott nodded cautiously. Kennedy smiled faintly. He once said that constitutional interpretation should be done with humility, that even the best legal minds must approach the text with reverence, not ego. Talcott didn't respond. So I ask you, Professor, where is the humility in mocking a man's education? Where is the reverence in assuming wisdom belongs only to the elite? Now it was personal, but Kennedy wasn't aiming to humiliate, only to reveal something deeper. I'll never claim to be the smartest man in the room, he said, but I've learned that the law doesn't need brilliance. It needs honesty, clarity, and the courage to follow the truth even when it's inconvenient. He paused, then added, especially when it's inconvenient. The audience shifted, some leaning forward unconsciously. Talcott, now visibly unsettled, tried to regain ground. Senator, with all due respect, this isn't about elitism. It's about expertise. The Constitution is too complex for simplistic interpretations. Kennedy nodded. Exactly. Which is why we should be careful not to confuse complexity with clarity. The Constitution may be complex in application, but its principles are beautifully simple. Freedom, justice, accountability. He let the words hang. And it was written, Kennedy said, not for scholars, but for citizens. The room erupted in quiet applause, brief but sincere. Talcott glanced toward the moderator, then to the audience, clearly aware the momentum had slipped beyond reach. His voice cracked slightly. So what then? Are we to believe that every politician with a law degree should define constitutional meaning? Kennedy answered softly. No, but every citizen has a right to understand it. And every servant of the people, elected or appointed, has a duty to honor that understanding, not obscure it behind credentials. It was a final blow, not in anger, but in clarity. A closing argument disguised as conversation. For a moment, no one spoke. Talcott sat back, his posture no longer upright. He looked smaller somehow, not defeated but disarmed. Kennedy, on the other hand, looked exactly the same as he had at the beginning, composed, quiet, respectful. But now the entire room saw him differently. When the session ended, it wasn't with the usual flurry of networking or academic posturing. There was a stillness that lingered, as if everyone needed a moment to absorb what had just unfolded. Doctor. Talcott left the stage quickly, his expression neutral, but his pace revealing a quiet urgency. No one stopped him. No one needed to. Meanwhile, students clustered around John Neely Kennedy. Some approached hesitantly, others with clear admiration in their eyes. Questions flowed, about law, about life, about how to keep one's voice steady when others try to drown it out. Kennedy answered each question patiently, not with grandstanding, but with the calm of someone who understood that truth didn't need to be loud, it just needed to be clear. One student, nervously adjusting his glasses, asked, "Senator, how do you stay so composed when someone attacks your background like that?" Kennedy smiled, then replied, "Son, if you grow up in Louisiana and practice law there long enough, you learn that being underestimated is just part of the job. What matters is knowing who you are and never mistaking credentials for character." Another student chimed in, "Do you think what happened here today will change anything?" Kennedy paused, then answered, "Maybe not right away. But maybe someone here will carry this moment with them. Maybe they'll speak up when it matters." That's enough. The gathering dispersed slowly, reluctant to break the energy that had taken root in that room. But the impression remained, a kind of quiet respect that doesn't vanish with applause. In the days that followed, clips from the event began circulating online. At first, it was just a few students sharing Kennedy's remarks, but then legal blogs picked it up, then news outlets, then influencers and commentators, each framing it as more than a debate. It was a reminder that substance still matters, that humility can overcome arrogance, that clarity can pierce through pretense, and that a man from Louisiana, educated outside the ivy walls, could stand on a stage of academic elites and not just hold his own, but command the moment. In private legal forums, professors debated whether Talcott had gone too far or if Kennedy had merely been too sharp to dismiss. In classrooms, Kennedy's lines were quoted during lectures on constitutional interpretation. But for Kennedy himself, none of that mattered much. When asked about it later by a journalist, he simply said, "I wasn't trying to win anything. I was just telling the truth." The incident became a story passed from law student to law student, a kind of parable, not because it was dramatic, but because it was real, a reminder that brilliance doesn't always come dressed in accolades. Sometimes it comes in a quiet voice with a southern drawl, speaking truth without fear. So the next time someone questions your background, your education, or your voice, remember John Neely Kennedy. Remember how he didn't fight fire with fire. He fought with facts, with patience, with purpose. And in doing so, he didn't just win an argument. He taught a room full of future lawyers what it truly means to defend the Constitution. If this powerful moment moved you, don't forget to subscribe. These stories matter, and yours might be next. Click on the video now appearing on your screen to continue watching stories of courage, humility, and unexpected brilliance. You don't want to miss it.